Rules guiding admissibility of documents. So I'll just go ahead and explain to us. And if you have this book, you will see I have discussed other things you need to know concerning documentary evidence. I've discussed some other things here. So talking about rules guiding admissibility, what this simply means is that before a documentary evidence is tendered and relied upon, there are rules that must be satisfied for that document to be admissible in law. Basically, when we are talking about admissibility of documents, we are looking at admissibility in civil proceedings as well as admissibility in what? Criminal litigation. Differences are not much, only that in civil proceedings or civil litigation, for you to rely and tender a document, that document must be what? It must be pleaded. That document must be pleaded. By pleading, we simply mean that when, assuming is a matter pending in the High Court, and I'm the claimant, I have filed my writ of summons, accompanied with the statement of claim and other documents. And in the statement of claim, I have said something like, I bought the land in dispute from Mr. A. So when I bought that piece of land, the person that sold to me issued me with a receipt. And that the receipt is dated, I may quote the date. And I will also say that at the trial, I will rely on the receipt. Just to say that the claimant shall at the trial, just the third person pronoun, the claimant shall at the trial tender and rely upon the receipt issued to him by Mr. A. And then maybe that is just not all. After that, it could be a power of attorney was also executed in favor of the claimant. And then in my pleading, I also go ahead to say that after the receipt was issued, a couple of days thereafter, a deed of irrevocable power of attorney was executed in favor of the claimant, duly signed by the vendor and his witnesses. The said document was registered at the land registry, Omaya, and same shall be relied upon at the trial. Same shall be relied upon at the trial. What have I done in effect? I have given the other party notice, the defendant. I'm giving him notice, look, I'm coming with these two documents. And when he sees my processes, he will see copies of them attached. All right. So he is not, taken aback. He is not surprised as to whether this document shall be relied upon or not. So he already knows my case, right? That is pleading. So for me to tender those documents that I mentioned, I must have done what? I must have pleaded. Now look at the other side of it. Contrarily, if I simply say that I am the owner of so land, I might have said I purchased it from Mr. A. That's also going to be a little bit technical. Without more, it will be difficult for me to start tendering receipt, tendering power of attorney. Although the Supreme Court has said, once you mention the transaction, it will now be understood that the document will follow, or you have to do what? Mention the document, even if you don't provide the particulars. So it is a different thing where I have not mentioned any document at all. I simply said the land is mine. I don't know why this man is dragging the land. He's known to be a land grabber. There are people like that. Instead of facing the fact, they will just be beating about the bush. Let's take, for instance, that I've already beaten about the bush in my statement of claim. I cannot tender any of those documents. Why? Because I have not done what? Good. So that's one of the conditions for guiding admissibility of documents. And another one, the second one, is that the document I want to tender and rely upon must be what? Relevant. It must be relevant to my case. The document to be relied upon must be relevant to my case. You know, most of the times when a document is sought to be tendered, the opposing party will just, rise up to raise objection, because some people, they feel like the best way to fight is that raise objection in every document. Now, assuming that I said this is the document with which I bought the land, it was issued to me, and somebody said, oh no, it is not relevant, he cannot tender it. Relevant to who? So relevancy there is restricted to what? My own case. It must be relevant to my own case. In other words, there must be a nexus between my case and the document. But if I'm saying that Mr. A issued a receipt and a power of attorney in my favor, and when I'm tendering another document which Mr. A issued to Mr. F, if I try doing that, the opposition will be right to say that the document is not what? Relevant. In other words, there must be a link, there must be a nexus between the subject matter and the case that I'm making out of it. So that document must be relevant to me, even if the other party thinks it's not relevant to him. So long as I feel that the document is relevant to me, I can do what? I can rely on it. And as a matter of a guiding principle, that condition must be what? Satisfied, the relevancy. And now the third one, the two that I've said earlier are usually the common one. But the third one is that this document that I want to tender must be legally admissible. It must be legally admissible. The document sought to be tendered must be legally admissible. It must be legally admissible. That's the third one. What I mean by a document being legally admissible is that there must not be anything that has tainted the document to make it either invalid. For instance, if I have procured this document by way of misrepresentation, by way of fraud, the sanctimonious nature of that document has been what? Vitiated. So one would be right to raise an objection to say that the document is what? Not legally admissible. Sometimes the court can say, okay, let's admit. After admitting, we'll look at the weight. I'm going to explain the meaning of weight. Another instance where a document may not be legally admissible is that if, for instance, a certificate of occupancy had already been revoked and I'm relying on it, because it has been revoked, in the eyes of law, it does not do what? It does not exist. Right? So it becomes what? Legally inadmissible. Now again, cast your mind back to your legal drafting. If I have a document that is not signed, is what? Is a worthless piece of paper, is a trash. So I cannot rely on it. Why? Because that document is what? Legally inadmissible. And now finally, which is the fourth point, and this fourth point is the innovation of the Evidence Act of 2011. It doesn't, in the past it wasn't there, but now there's no way we can close our eyes to it. It has become part of our lex lata. And that is that if there is a legal requirement or a legal condition, that condition must have been satisfied before I can rely on it. Legal conditions to be satisfied. You can put in bracket condition precedent. I'm going to give you an example. Condition precedent. Now, we when we are talking about the meaning of document, so we looked at various types of documents that now exist. Now, each of these documents has its own characteristics and conditions for admissibility. And principally too, if the document that I want to tender is a computer-generated document, then I must do what? Comply with the law. And that law is what? Section 84. I must comply with Section 84. What does it say? Section 84 says, in any proceeding, a statement contained in a document produced by a computer shall be admissible as evidence of any fact stated in it, of which direct oral evidence will be admissible if it is shown that the conditions in subsection 2, those are the conditions precedent. We are going to look at what subsection 2 says. Or the section are satisfied. So in other words, Section 84 1 is saying, do you want to tender document printed from computer? Good, you can tender. It's admissible. Right. But there are things you must do what? Do. There are conditions precedent to the admissibility of the computer-generated evidence. And that's in subsection 2 of section what? 84. So we look at it. I said the conditions are 1. That the document containing the statement was produced by the computer during a period over which the computer was used regularly to store or process information for the purposes of any activities regularly carried on over that period, whether for profit or not, anybody, whether corporate or not, or by an individual. First of all, what is the reliability of the computer that you used? You must show it as a condition precedent. So when I am pleading that he sent me a mail from Algeria, and that this mail, I'm going to rely upon it, I printed it out from my computer. So I'm going to describe my kind of computer. And I'm going to satisfy section 84, subsection 1A, subsection 2A, by saying that this computer was functional. It was in good condition as at the time that I printed this thing out. So it's not like it's going to be an Oluwole that is manufactured in code, is doctored. That this computer was being regularly used as at that very time. And then again, the next condition, that over that period there was regularly supplied to the computer in the ordinary course of activities information of that kind. So that this computer that I used to print out this information, the information is not the first of its kind that this computer is printing. Before the information came in, I was using the computer to print out similar information, just like later. Similar does not mean exactly the same, all right? And then again, see that throughout the material part of that period, the computer was operating properly, or if not, that in any respect in which it was not operating properly, or was out of operation during that part of that period, was not such as to affect the production of the document or accuracy of its content. Accuracy. You must show that this document that emanated from your computer has the accuracy that is not affected maybe by the breaking down nature of your computer, just like NEPA. They come now tomorrow, after some minutes, it disappears. And this place is saying that as a human being and as a natural thing, even if this computer has broken down at any particular time, tell us that the fact that it broke down did not affect what? The production and the reliability of the document or the accuracy of the document that it has done what? Produced. It's possible for a document to be produced from a computer not being very accurate. Am I right? Can you give me an example of what can cause that inaccuracy, or an example of that inaccuracy? You play something from computer, it's not showing you exactly what was fed into it from the other end. An example?
When there is a corruption of a file by a virus.
If virus had already corrupted the file. All right? Any other thing? Those who are quarreling, what's the problem? They are looking back. You are the one making noise and you're looking back. Okay, now the next condition here is that the information contained in the statement reproduces or is derived from the information supplied to the computer. What was garbage in was what was garbage out. That's what he simply said. So all these conditions must what be there. So if you feel that this is cumbersome, I'm not going to bother myself with it, and then you file it, you can't tender that document. Why? Because you have not done what? Satisfied the conditions precedent. And then again, when you look at subsection 3, some of the times it seems to create a kind of issues. But we just go down and then I'll explain to you. Subsection 3 says, wherever the period, the function of storing or processing information for the purposes of any activities regularly carried on over that period as mentioned in sub 2 of this section was regularly performed by computers. Now this is another condition. If what you are tendering was not produced by only one computer, but either by 2 or amalgamation of computers, you must do what? Repeat all these conditions and tell us that this thing, it is reliable, there's no corruption, it's exactly the same thing, in as much as I use this product, merge it with this product. There are things you want to produce. For instance, in cinematography, you could have like 3 computers, to produce it. Then even the VAR that you see, you watch in football, these are amalgamation of the workability of what? Computers. One comes from the reverse angle, one comes from the other angle, one comes from the direct, and then the other angle, in order to ensure that what you are watching, what you are suspecting, happened or did not happen. Credibility. Then again, where you have such a combination, you just tell us that this combination of computers operated regularly, so all those conditions. And then 4 now, subsection 4 says, in any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate identifying the document containing the statement, giving such particulars of the devices, dealing with the matters and all these are another condition. But what the Supreme Court has been able to do in respect of section 4, subsection 4, is to show us that the one that is very compulsory is what? The earlier one, the subsection 2. That this one is merely what? Permissible. And this one you can simply do what? Incorporate it into your pleadings. It only takes a lazy attorney not to bend down and do this. There's nothing too difficult there. Do you understand? Just to do a certificate. The certificate can either be by an affidavit or it can also be by way of what you have pleaded. It's just a kind of being what? Corroborating all the conditions that you have stated that you have already done what? Satisfied. But if you don't have it and you have the earlier one, it will also be what? Admissible. All right. So that's talking about conditions for admissibility, rules guiding admissibility. Then after this, you now have, if before my document is admitted, how do I prove my document? What do I tender? Proof of documentary evidence. What do I tender? Now, when you are talking about what to tender, it simply means what quality of document do you have? And in order to answer that question, I'll give us an example. We draw our illustration from oral evidence. You know, like oral evidence is admissible from whom? What are the conditions for admissibility of oral evidence? Let's go from there. What are the conditions admissibility of oral evidence? Don't tell me you have forgotten.
If he relates to a fact which was seen, he must proceed from a person who has seen it.
Okay.
A fact heard from a person who has heard it.
Okay.
A fact perceived must be from such person who has such perception.
Exactly. So now, when you are giving oral evidence of what you saw, it is said to be what? Direct evidence. And when you also, the same rule also applies to documentary evidence. Because documentary evidence is known as what? The best evidence. So it has to come from the person who has written the document. We also come into that. But before we get to who wrote it, the next thing we want to, the first question we want to answer is that, what do I tender? Let's say, for instance, I've talked about receipt issued to me when I bought the land, and I want to tender the receipt. The law is that I must tender what? What do I tender? The original. What is it called? The primary evidence. So, when you're talking about proof, there are two ways of proving a document, primary or secondary. So, primary simply means that my best evidence is what I need to tender. That my original copy of the document is what I have to tender. Adventure, I don't have the original, and all I have is what? Maybe the photocopy. All I have is the photocopy. Before I can make up my mind whether I'm tendering it or not, I had to ask myself one question. What is that question? Let's maintain our practice. So what is the question I should ask myself before I tender the document? If my question is, we are talking about proof of document now, and I had now been acquainted, just like every one of us, that the document I need to tender must be what? Original. And that is what? Primary evidence. Now, primary evidence is the best evidence. It's just like giving a direct evidence, right? Now, in terms of document, I must tender my original or primary evidence. But what if I look for it, I could only see the photocopy? And then there's a question I must ask myself before I will now go further to rely on that document. What is that question? What question must I ask myself? Right? The question you have to ask yourself, this document that we are just running around the answer. This document that I don't have the original, I only have a photocopy. What is the nature? What type of document is it? The type of document it is tells me what to plead, tells me how to prove it. Right. If it is a private document, then I will relax. I know that I can do what? Tender the secondary evidence. If only I can do what? Lay the foundation. To tell about what happened to the original. Maybe it is lost. I have searched for it. I couldn't find it. My shop got burnt. It got burnt there, and I don't have original copy. Before getting burnt, I had the photocopy. You are now pleading what? The secondary evidence. But it's a different thing if that document is what? It's a public document. You know why? Because if it's a public document and I have the photocopy, I cannot do what? It becomes inadmissible. So for those who want to certify, you cannot certify. It becomes inadmissible because you can't tender photocopy of a public document. What would you rather tender? Certified true copy. But if it's a document that is made by the same uniform process and you have it, you can tender it. But if you don't have it, you now go to what? The authority that has it. make an application for a certified true copy of that document to be issued to you. And when it is issued to you, you cannot come to court and tender it. But then, you must also make sure that the certification is correctly done. I'm just giving you a summary so that when you on your own start reading maybe books on it, you would have discovered that I have watered the ground for you. Now, how is the document certified? The law requires that the certifying authority must place its stamp on that document. Naturally, it's the photocopy of the document now. It will place its stamp on it, write the name of the certifying officer, and the rank of the certifying officer. The rank of the certifying officer must be there, as well as the date of certification. And if any money was paid, the amount paid must be what? Be endorsed on the document. Now there is this argument whether a public document has a secondary proof or not, whether a public document can be proved by the secondary means. You know, when you talk about the private document, secondary means of proving it is by what? By the photocopy of it. But when you are talking about public document, why? Because that public document will only just be one in the custody of that authority. They can't give it to you. What they will simply do is to do what? Photocopy it and stamp it, just like in the archive, so that that document will still remain for other people's use. Do you understand? So the question now is, this document that has been stamped and certified, and I'm tendering it, am I tendering it as a secondary evidence or a primary evidence? Who can try that? Is it being tendered as a primary or a secondary evidence? If you break my rule again, I'll break your head. All right, let's stop. What makes you think is a primary evidence? It has been certified. But what about the one they are holding? What they have simply done is to do a photocopy and stamp and give to you. So do you think it's secondary or primary? Who is saying it's secondary? Let's hear you.
It's secondary because Section 88 has already provided that all documents shall be proved by primary evidence, except as provided in the cases held in affirmation. And that certified copy is part of those cases held in affirmation.
Held in affirmation as exception?
Yes, to the general.
Now, if it's an exception to the general rule, do you think still say it's a secondary evidence? If it's coming in as an exception, are you still saying it's a general primary or secondary evidence? Secondary. What provision did you cite? We are coming close to the debate now. And what provision is that? 88. Documents shall be proved by primary evidence, except as mentioned in this act. Mentioned by primary evidence, except as mentioned in this act. So what makes you think is, it has not said any other thing here. Secondary evidence may be given of the existence of this blah 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 blah. Power of actually any other document legally existing. Okay, let me tell you what the problem is. When you look at sub C here, he said the original is when the original is a public document within the meaning of section 102. Now, when you look at Evidence Act, especially this 88 sub E, it looks like it is somehow contradictory. When you juxtapose it against Supreme Court decisions, what are the Supreme Court decisions? You will see some of them here. The Supreme Court has said that a certified true copy is as good as what? Original. That means when I'm tendering a certified true copy, what am I tendering? Original. That's what the Supreme Court has said. And that has also brought in another confusion. Whether a photocopy of a certified copy is admissible. Did you get that? Whether a photocopy of a certified true copy of a public document is admissible, what is your view? What do you think? I have certified this document and I just photocopy it so that I don't lose it. Or maybe I've lost it and I have a photocopy and I'm coming to tender it. What is your view? Why would it be a secondary evidence when, by what the Supreme Court has said, public document has no secondary evidence? We have 2 or 3 conflicting decisions of the Court of Appeal.
Yes, you are actually correct. There has been divergent views concerning that. And in the case of Magaji against the Nigerian Army, they held that it is admissible. That is a photocopy of the certified copy is admissible.
Magaji and Nigerian Army, who made that pronouncement, was it a ratio or was it a dictum?
It was an opinion. It was a dictum.
It was not a ratio decided deal. So that's a problem. If not that matter, Supreme Court would have rested the issue. But up to today, that issue is yet to be rested. Now look at this scenario. The reasoning of the Court of Appeal is that when you certify a document and tender it, good, we take it as what? Original. No photocopy, no primary evidence. When you tender a certified true copy of a document, what you have done is that you have proved your case by what? Primary evidence. Right. Now, if you go ahead to photocopy it and bring the photocopy, either you intended to do that or you have lost the main one you certified, the court will simply tell you that public document has no secondary proof. So that's the reasoning of the Court of Appeal. And then the Court of Appeal also said that there is the probability of manipulation, except if it can be compared. That's the second decision now that said that, is it not the same thing? Let's just admit it. But the law is not simply, is it not the same thing? You understand? And I'm surprised that up to now there has not been any case stated. When you look at that case of Magaji and Nigerian Army, it was not the issue. That Magaji relied on the pronouncement of Ogbuagu JAC. When way back, Ogbuagu JAC looked at that situation and he opined that for him, there is nothing wrong in somebody tendering a photocopy of a certified document. So long as nothing has changed, it can be compared and found to be the same thing. That's almost the ratio in Magaji. So it was not a live issue in Magaji and the Nigerian Army. So those are the kind of confusion you have when you come in contact with proof of public document. So that if, for instance, you are asked to discuss, so in your discussion, those are the things you're going to, but try to read it. Try also to read maybe articles that have discussed those issues. So we have been able to look at the rules guiding admissibility of documents. We have looked at also where the law has provided for condition precedent, and we have looked at the means of proof. And we said, if what you want to prove is a private document, what is required as a general rule is what? Primary. If you in private is primary. But if you don't have it, you can do what? Rely on your secondary evidence. But tell us what happened to the original, why you can't tender the original. But if it's in public document, don't bother explaining anything. Just do what? Go and get the certified true copy of the document and do what? And tender. So this remains the present situation of the law. So, so far so good. We take a date to look at some other group assignment. Please, on your own, I'm also going to discuss it. I'm going to discuss section 30 alongside section 83 because I think it was a mistake to ask the group to discuss section 80, section 30, right? But then it is all good. There's nothing damaging about it. When you look at section 30, just opposite with section 29, subsection 2, and section 14, you arrive at the